I'm the natural person, I'm the living man. For the record, my name is Thomas Styron II. It is not the name you have attached to this case. I believe that's a state created entity, Your Honor. And me being a living person. My name is in proper punctuation. I don't have a all caps name. So this is under the assumption that you guys have personal jurisdiction and subject matter jurisdiction over me, right?
Yes.
Today's hearing quickly turns intense as a defendant, using sovereign citizen-style arguments, attempts to challenge the authority of the court. He repeats familiar claims that the court lacks jurisdiction over him, yet his statements show little understanding of how legal authority is actually established. Court jurisdiction is defined by constitutional and statutory law, not by personal belief or refusal to consent. As the exchange unfolds, it becomes clear that confidence alone cannot replace preparation or knowledge of procedure. Arguing with a judge without a solid legal foundation rarely leads to a favorable outcome, especially when the judge applies the law every day as part of their professional duty. The contrast between practiced judicial reasoning and improvised claims creates a tense but revealing moment inside the courtroom. Rather than shifting the course of the case, his approach appears to highlight the gap between theory and reality. Let us step into the hearing and observe how the court addresses these arguments and restores focus to the legal issues that truly matter.
Good morning. 14B District Court is now in session. This is Magistrate Hillary Braley presiding. Okay, and I need you unmuted at the jail. There we go. Can I have your name, please?
For the record, my name is Thomas Styron II. I'm the natural person, I'm the living man. How we doing today, Miss Braley?
We are upright, if nothing else. So, okay. And you said your name is Thomas Styron.
The second.
The second.
And then I'm the natural person, the living man.
Okay, thank you for your patience there. We had a little bit of a kerfuffle. So,
No problem.
recalling case number 19S00472, that is the state of Michigan versus Thomas Ulrich Styron, the second, you said, and also calling 24W001025, that is the township of Ypsilanti, also versus Thomas Ulrich Styron. So state your name for the record.
So, for the record, my name is Thomas Styron II. It is not the name you have attached to this case is not me. I believe that's a state created entity, Your Honor. And me being a living person. I don't. My name is in proper punctuation. I don't have a all caps name nor.
Okay, I'm going to cut you off right there.
His presentation in court raises serious questions about preparation because repeating technical terms without clear understanding rarely strengthens a defense. When he begins discussing jurisdiction and unusual interpretations of punctuation, it becomes evident that the argument lacks grounding in established legal doctrine. Courts rely on statutes, case law, and procedural rules rather than creative reinterpretations of wording. Attempting to reshape legal meaning without credible authority behind it only weakens credibility in front of the bench. The judge appears composed and at moments slightly amused, which suggests she recognizes the disconnect between his claims and actual law. Confidence without research does not carry weight in a courtroom where precedent and evidence guide decisions. Instead of advancing his position, the delivery highlights confusion about how jurisdiction truly functions. As the hearing continues, the judge's response at the conclusion brings clarity and firmly redirects the discussion back to established legal standards.
I don't have no contracts with the state of Michigan at all, period. And so I was wondering about personal jurisdiction, subject matter jurisdiction in regards to this.
Okay. And you can continue to wonder about those at the moment. What I am doing, you have a show cause hearing on the matter ending in 472, which is the retail fraud charge. I'm showing a balance of $210 on that. And then what you're being arraigned on, that is what I am here to explain the charge against you, is a citation issued on April 2nd, 2024 at 9:24 in the evening that charges that you operated a motor vehicle on North Ford Boulevard at or near Russell Street with no license on your person. Do you comprehend the charge against you?
I do not. I don't even own a license. I canceled my license years ago.
Okay. So, what you are being charged with is operating a motor vehicle without having a license on your person. So, I'm not asking if you agree with this. I'm not asking if you have a license. I'm asking if you understand the words coming out of my mouth as far as what this charge is.
The charge is accused me of not having a driver's license on my person, correct?
Correct.
Well, from my understanding, I need a driver's license if I'm in commerce. I was traveling home.
Okay.
I wasn't doing business at all. And also from my understanding, I don't need a license to do that.
And your overstanding is incorrect, sir. But we are not going to get into that.
At this point in the hearing, it almost sounds like he is providing information that strengthens the case against him. The original charge involves driving without a valid license, yet he openly admits that he has not held one for 2 years. He then attempts to separate the concept of driving from traveling, which is a common sovereign citizen style argument, but one that courts have repeatedly rejected. In most jurisdictions, operating a motor vehicle on public roads requires a valid license regardless of how the activity is described. Voluntarily confirming the absence of a license while contesting terminology does little to resolve the core issue. While his tone may appear respectful, the substance of his statement suggests a misunderstanding of how traffic laws are structured and enforced. Licensing requirements exist as part of regulatory systems designed to promote public safety rather than to create technical word debates. The exchange highlights how important it is to understand the legal definitions that apply within statutory law. As the hearing continues, the judge will likely focus on the factual elements of the charge rather than the alternative interpretations being presented.
For now, you are saying that you have understood the words as far as not having a license on your person. It is a misdemeanor charge with a maximum penalty of up to 93 days in jail, a $500 fine with court costs, or both.
So this is under the assumption that you guys have personal jurisdiction and subject matter jurisdiction over me, right?
Yes.
So
at this time, the court is going to set a pre-trial date for you. That will be before Judge Washington.
Ma'am, can we prove the jurisdiction first before we go ahead with setting a trial for that entity or a pre-trial for that entity?
I hear you, and at this point you are appearing in front of the court. You have put your name on the record, and yes, we are setting a pre-trial date for you.
I did put my name on the record, and my name that I put on the record is not the same name that you have attached to that case.
And you can provide documentation of such at your pre-trial date, which is going to be June 26th.
So the documentation that I have published, recorded the documentation I have published and recorded on the record, on the state of Michigan record, that says what I just told you, that I'm not who you have, that I'm not the name you have attached to that case. That's I need to bring that with me, is what you're saying? It being already recorded and on the state of Michigan records. That good enough?
Whatever documentation you have,
Mm-hmm.
bring it with you to your pre-trial date. That is what I am telling you, yes. So, and again, that court date, June 26th? Okay. Will be June 26th at 9 a.m. before Judge Washington. The court will enter that you are standing mute to all charges at this time.
So we're just assuming jurisdiction, though, correct?
Yes.
How? From my understanding, that has to be proved before we even proceed with anything else. Am I wrong?
you are not correct. The court will also set a personal recognizance bond in this matter. Basically, you are promising to show up for that June 24th court date at 9 a.m. over Zoom before Judge Washington, where you will have your pretrial. Okay, so at this point, your hearings are concluded. You are free to stand up and tell the jail that you are finished.
So I need to be there under threat, duress, coercion of going to jail.
The judge in this hearing demonstrated strong courtroom management skills while addressing the sovereign citizen arguments presented before her. Although she allowed the defendant space to speak, she stepped in decisively whenever the discussion drifted away from relevant legal issues. Her approach combined patience with firmness, which is often necessary when handling unsupported claims built on misunderstood legal terminology. Rather than appearing unsettled, she maintained steady control and responded with clarity that reinforced the authority of the court. Confidence from the bench is essential when a defendant attempts to overwhelm the process with jargon or repeated assertions lacking legal foundation. Regarding remote proceedings, virtual court has expanded access and efficiency in many jurisdictions, yet it can also introduce challenges with interruptions and maintaining decorum. Some observers feel that in-person hearings carry a greater sense of gravity, while others appreciate the convenience and accessibility that online platforms provide. Regardless of the format, the effectiveness of a hearing ultimately depends on how well the judge manages communication and keeps the focus on established law. Overall, this case highlights the importance of measured leadership when addressing unconventional defenses. Share your thoughts on both the judge's handling of the situation and the role of virtual hearings in maintaining courtroom order as we conclude this discussion.